This is a lecture for my professional responsibility class, and we're going to be talking about waivers for malpractice, legal malpractice actions, and settling malpractice actions, which are covered under Model Rule 1.8 H. 1.8 H. This rule, 1.8H, is part of a cluster of rules about conflicts of interest between the lawyer and the client. Most of the conflicts of interest rules are about clients versus clients, either present clients that the lawyer's representing at the same time, or past clients and new clients. But the 1.8 rules are about your kind of self-interest and how this causes conflicts of interest with your client. And this one has two parts. One, a lawyer shall not make an agreement prospectively limiting the lawyer's liability to a client for malpractice unless the client is independently represented in making the agreement. Or two, settle a claim for a potential claim for such liability with an unrepresented client or former client, unless that person is advised in writing of the desirability of seeking and is given a reasonable opportunity to seek the advice of independent legal counsel in connection therewith. So let's talk about the second prong first before we move on. And then the first prong actually requires a little more discussion and explanation for law students. The second one is, let's say you realize you've blown it, and where your client confronts you and accuses you of screwing up and botching the representation of them, and so, or you do the grown-up thing and make a mea culpa phone call, like you call your client and say, "I screwed up. I don't know what I was thinking, and I kind of ruined your case." And so either if the client is suing you or you're informing the client that you really messed up, you then say, look, why don't I make this whole? We could go have a big old trial and everything, but you're right, and so I'm just going to pay you. Well, at that point, they need to have another lawyer, right? So we're very worried about lawyers manipulating or exploiting the unrepresented client and talking them into a deal that doesn't really compensate them. So you at least have to advise them in writing, and you don't get to do something like say, and you haven't, this deal's off the table or offers off the table at midnight tonight or tomorrow morning or something like that. You have to give them some time, let's say a couple of weeks, to call another lawyer, make an appointment, go in for a consultation, and so forth. Um, or they may say, I don't want to get another lawyer, but you've advised them in writing at least that it would be advisable that they do it, and then you can settle the case. Now, let's go back and talk for a moment about part one, H1. And this is where it says that you can't do waivers up front. And I have two things to say about this. First of all, in your first year law classes, you may have learned in torts or other things that that it's pretty common for people to ask for liability waivers, or think of summer camps where people send their kids, or you want to go bungee jumping or assume some sort of risky activity, and so it's pretty common that you'll be asked to sign a waiver of liability, and that's normal. We don't let lawyers do that. So as a lawyer, and I suppose if we did, everyone would do it. Everyone would just, at the same time they were having a client sign the fee agreement or sign a power of attorney, they would say, oh, and here's where you waive liability. We simply don't let you do that with your client, and or ask for a waiver. And then we have one exception, and that is where your client is represented by another lawyer, and that lawyer advises them to go ahead and sign it, to sign the liability waiver. And now you may have two questions right now. Why would my client ever have another lawyer sitting right there already? And why would that lawyer tell them to go ahead and sign it? So let's talk about the scenarios. We're going to tick off a few right away, and I want you to have these in your mind because it relates to this, and it's actually going to come up with a few other rules in the future. What happens when this one client has multiple lawyers? So the first scenario is you're representing an organization, a business, and they have in-house legal counsel, and that person has outsourced some of their legal work, let's say litigation, to you. And so if that person, in that case, they have a lawyer who is retaining outside counsel, you can ask, and they may tell them, you know what, this is a straightforward matter, and so we can waive malpractice liability or something like that. And or you don't want to, you're concerned, you don't want to be responsible, sued for what in-house counsel has been advising the management of the company. So if the company is represented by counsel, their in-house counsel, and they're your client, then you can get a waiver. Next, let's say that they have, it's an individual who has a lawyer that they use for their transactional work, who it's a small business owner, and they have a lawyer who reviews their contracts and leases and vendor agreements and things like that. And now they have litigation, and so that person has referred them to you to handle a lawsuit for them. And so there's a lot of lawyers. I know there's some lawyers who just do everything, but there's a lot of people who do transactional work who don't do litigation, and there's a lot of litigators who don't really do transactional work. And so you could be a litigator referring someone, your client wants someone to do their will or something like that, or their real estate residential real estate closing, and you're referring them to someone else. And again, so there you are, they have another lawyer who can tell them, yeah, you should go ahead and sign that, it doesn't matter. The same is true with trial lawyers versus appellate lawyers. A lot of people who do appellate work don't do trials. A lot of trial lawyers don't do appellate work because it's a very different skill set. To be honest, it's a very different type of work, a very different type of stress, and a different pace. And appellate work requires a lot more research and writing and so forth. And so when you have a trial and it's going up on appeal, it would be permissible for the appellate lawyer to say, I want a waiver of liability, and for the trial lawyer to advise the client to do it. And we could go on and on, right? The appellate lawyer is referring it back to a trial lawyer after remand and so forth. Let's talk about another scenario, though. And this happened to me when I started my first job after law school. And I was working for a legal aid clinic. It was an inner city clinic that provided free legal services for indigent clients in Hartford, Connecticut. So I was a legal aid lawyer after law school, and the another lawyer in our agency, our legal aid clinic, had represented a client against a landlord and won whatever type of relief. It was an eviction or something like that. And then the landlord was a sore loser. And so he turned around, and he was pro se. A lawyer would have told him not to do this. He was pro se. So his response to losing a round of litigation was to turn around and file a lawsuit that it was just unfair that he had been beaten, and he sued our client and our attorney who had represented that client for something like frivolously winning, which isn't really a claim, right? So you should be able to go into court and file a motion to dismiss. That's not a thing. That's not a justiciable claim and so forth, but you still have to file a motion. It just doesn't disappear into thin air because it's a ridiculous claim. Well, but we have a problem now, right? Because we now have a conflict of interest because our lawyer is a co-defendant in the same lawsuit as one of our clients. And so what do we do in this situation? We're going to have another lawyer come in, and we're going to transfer our client to them until we get the case against our own lawyer in our clinic dismissed. And when that happens, the conflict disappears, and so we can take our client back. We didn't expect any action on this case in the meantime, in the few months it was going to take to file these motions to dismiss and so forth. And so we didn't expect this other lawyer to have to do anything except what I would call it babysit the file in their drawer. They have to be the attorney of record in case notice gets sent out to the parties, or the court wants to bring everybody in for a conference or something like that. They have an attorney of record. They're no longer our client, so the conflict is we've resolved the conflict by sending the client to someone else. Then we get rid of the piece of litigation against our lawyer, and now we can take the client back. And this can happen, right? You have a conflict of interest arise, and it could be with you, a lawyer at your firm, and and one of your clients, or it could be between two of your clients. And you could ask another lawyer essentially to babysit one of the cases until you can, because you could quickly get the conflict resolved, and and dispensed with, and then take the client back. Again, if you're doing that, if you're agreeing to babysit somebody's file for them, you should totally ask for a waiver of malpractice, because are being told that you're not going to have to do much work on it. Any work being done is being done by the other lawyer who's asking you to take the case on for a little while, and they should tell the client, go ahead and sign the waiver. So there's all these things, transactional versus litigation, trial lawyers and appellate lawyers, or a firm has an unexpected conflict that has arisen. They need to transfer one of the clients to another lawyer, resolve the conflict, and then they could take the client back in theory. So all of these things can happen. Let's go back to our rule. Agreements prospectively limiting a lawyer's liability for malpractice. These are the comments. This is comment 14. For malpractice are prohibited unless the client is independently represented in making the agreement, because they're likely to undermine competent and diligent representation. And so part of what we're talking about here is what in some of your classes they may call moral hazard, right? Moral hazard is when you've eliminated any of your own skin in the game, and so you can take risks that you wouldn't take if you were worried about the consequences. Also, many clients are unable to evaluate the desirability of making such an agreement before the dispute has arisen, particularly if they are then represented by the lawyer seeking the agreement. So if it's just your client and you're their lawyer and you're telling them to do it and they're taking your advice, you're really taking advantage of them. This paragraph does not, however, prohibit a lawyer from entering into an agreement with the client to arbitrate legal malpractice claims, provided such agreements are enforceable and the client is fully informed of the scope and effect of the agreement. And we're going to see at the end, the ABA also put out a formal ethics opinion reiterating this point. You can have arbitration agreements in your sort of retainer letter or your engagement letter, your agreement to represent the client. Nor does this paragraph limit the ability of lawyers to practice in the form of a limited liability entity where prohibited by law, provided that each lawyer remains personally liable to the client for his or her own conduct and the firm complies with any conditions required by law, such as provisions requiring client notification or maintenance of adequate liability insurance. So you may have been thinking, wait, can law firms operate as an LLC or an LLP or something like that? Not all states have the same organizations, and the states vary somewhat in the requirements that they have. Some states require, if it's a professional organization, association like lawyers or doctors, that they use an LLP instead of an LLC. But that obviously limits your liability. You are allowed to do that, but that's going to have disclosure requirements and things like that. It's going to be like right on your sign that you're an LLP and so forth. If you're not sure what that means, it doesn't mean the person can't sue you. It limits the amount of your personal assets that will be at stake in lawsuits. In other words, when you have an LLC or an LLP or other types of a PC, a professional corporation, and some of these entities, essentially the money that the lawyers have in the organization, in the firm, that could be subject to judgment, and but they can't go through that and get to the lawyer's personal assets, in a sense. Nor does it prohibit an agreement in accordance with Rule 1.2 that defines the scope of the representation, although a definition of the scope that makes the obligation of representation illusory will amount to an attempt to limit liability. In other words, it's a really good idea. If you have no intention of doing the trial, if something goes wrong when you're drafting contracts, put it in your representation agreement upfront contractually. I am only drafting the contract for you. I am not going to do any litigation that arises out of this. And then you can kind of limit the scope. If you're a trial lawyer and you really don't do appellate work, put it in the agreement with your client up front that you're not going to do the appeals. It will cover your back later, that this was clearly communicated. And so you can limit the scope of representation. Sometimes you may have a client who comes to you and you say, look, this isn't really my area. I don't want to do this. And but they think that they could resolve the matter. Let's say it's a complaint with a neighbor against a neighbor or something like that over a boundary dispute with a simple demand letter. And so you would go ahead, write a scope of representation that says, I agree to send a letter, make a phone call, and that's it. I'm not going to enter litigation, file pleadings, or do discovery or anything like that. And all of that is fine. What you're not allowed to do is have a letter that says, I do not have to try or provide competent representation or diligent representation, and basically words that are tantamount to saying you can't sue me no matter how bad of a job I do. So you're not allowed to say, I do not agree to provide full legal representation for this matter. Just say my representation is confined to this type of task. Agreements settling a claim or a potential claim for malpractice are not prohibited by this rule. Nevertheless, in view of the danger that a lawyer will take unfair advantage of an unrepresented client or former client, the lawyer must first advise such a person in writing of the appropriateness of independent representation in connection with such a settlement. And so you need to you at least have to disclose to them, advise them in writing that it would be in their interest to talk to another lawyer. This is comment 15 that we've been talking about now to Rule 1.8. In addition, the lawyer must give the client or former client a reasonable opportunity to find and consult independent counsel. As I explained, you're not allowed to say, I'm willing to settle the case. I'll give you $50,000 if you'll settle this malpractice claim against me, but the deal's off the table in an hour, or the deal's off the table tomorrow morning, or something like that. It takes a while for somebody to schedule an appointment and with another lawyer and go in for a consultation, and you are going to have to give them time to do that. Okay, there's an ABA ethics opinion from 2002 that has now been incorporated into the official comments to the rule that allowed binding arbitration agreements with clients. These are permissible, but we don't have to spend more time on that because we've already talked about it. And as long ago as 1996, the ABA had a formal ethics opinion allowing law firms to operate as LLCs or LLPs. And again, we've already discussed this because that's been incorporated into the comments. Here's a review question about 1.8H. A client consulted with an attorney about providing representation in the client's upcoming litigation. The attorney agreed to think it over and perform a routine conflict check, and then informed the client within a few days about whether she would proceed with the representation. The attorney explained it was not an appealing case because the expected value of the lawsuit was low and it would entail tedious work during discovery. 2 hours after the consultation, the client called the attorney and offered to waive any potential malpractice claims against the attorney if the attorney would take the case. The attorney then agreed to the waiver and agreed to take the case. Was it permissible for the attorney to agree to the client's offer to waive the malpractice claim? A, yes, because the client offered it and the attorney did not ask for the waiver, so the agreement was permissible. B, yes, the client's offer of a waiver was consideration for the attorney agreeing to take a case that was otherwise not appealing. C, no agreements with clients limiting a lawyer's future liability for malpractice must be in writing. Or D, no, a lawyer may not make an agreement with an otherwise unrepresented client prospectively limiting the lawyer's liability to the client for malpractice, even if the client offers. Hopefully you know the answer to that from watching this video, and if you don't, I would encourage you to review this little lecture and make sure you're clear on the answer to this question.